Okay, we're live. We're going to read Semtek International versus Lockheed Martin Corp. By the Supreme Court of the United States, Scalia's opinion. This case presents the questions whether the claim preclusive effect of a federal judgment dismissing a diversity action on statute of limitations grounds is determined by law of the state in which the federal court sits. That's the issue. Petitioner filed a complaint against respondent in California state court alleging inducement of breach of contracts and various business torts. Respondent removed the case to the United States Court for the Central District of California. And on the basis of diversity of citizenship. See Section 1332441 of the United States Code, Title 28, under Title 28. The 1994 edition and Supplemental 4. And successfully moved to dismiss the petitioner's claims as barred by California's 2-year statute of limitations. In its order of dismissal, the district court, adopting language suggested by respondent, dismissed petitioner's claims in their entirety on the merits and with prejudice, without contesting the district court's designation of its dismissal as on the merits. Petitioner appealed to the Court of Appeals for the Ninth Circuit, which affirmed the district court's order. Petitioner also brought suit against respondent in the state circuit court for Baltimore City, Maryland, alleging the same causes of action which were not time barred under Maryland's 3-year statute of limitations. Respondents sought injunctive relief against this action from the California Federal Court under the All Writs Act of Section 1651 of the United States Code under Title 28 again, and removed the action to the United States District Court for the District of Maryland on federal question grounds. Diversity grounds were not available because Lockheed is a Maryland citizen. Semtek Int'l Inc. versus Lockheed Martin from the Federal Supplement of 1997. The California Federal Court denied the relief requested, and the Maryland Federal Court remanded the case to state court because the federal question arose only by way of defense. So here's a removal. So it was in diversity. And then somebody moved for motion or summary judgment. We're in Maryland now on federal question grounds and not diversity. And the California Federal Court denied the relief requested, and the Maryland Federal Court remanded the case to state court because the federal question arose only by way of defense. Following the hearing, this is tough. Book briefing is tough here. Because what does Maryland Federal Court mean? Like district court? I guess so, because it's talking about the district court here. So I'm going to say district court, Maryland, remands to state. Following the hearing, the Maryland State Court granted respondent's motion to dismiss on the grounds of res judicata. Petitioner then returned to the California Federal Court in the Ninth Circuit, unsuccessfully moving both courts to amend the former's earlier order so as to indicate that the dismissal was not on the merits. Petitioner also appealed the Maryland trial court's order of dismissal to the Maryland Court of Special Appeals. So, the trial court in Maryland dismissed. It's on appeal, and the Court of Special Appeals affirmed in Maryland, holding that regardless of whether California would have accorded claim preclusive effect to the statute of limitations dismissal by one of its own courts, the dismissal by the California federal court barred the complaint filed in Maryland, since the res judicata effect of federal diversity judgments is prescribed by federal law, under which the earlier dismissal was on the merits and claim preclusive. After the Maryland Court of Appeals declined to review the case, we granted cert. And that's the Supreme Court of the United States. And I'm like seeing the issue again now after all this procedural context is whether the California, I guess, federal court precluded an error because the case was not judged on its merits yet. By any other court. So that's where I think we're at. And we're going to go to part 2 of this case. Petitioner contends that the outcome of this case is controlled by Dupassier versus Rochereau, which held that, and this is 1875, which held that the res judicata effect of a federal diversity judgment is such as would belong to judgments of the state courts rendered under similar circumstances and may not be accorded any higher sanctity or effect. Since petitioner argues the dismissal of an action on statute of limitation grounds by California state court would not be claim preclusive, it follows. So that is what happened. It was a statute of limitation grounds. Okay. Would not be claim preclusive. It follows that the similar dismissal of this diversity action by the California federal court cannot be claim preclusive. While we agree that this would be the result demanded by Dupassier, the case is not dispositive because it was decided under the Conformity Act of 1872, 17 Stat 196, which required federal courts to apply the procedural law of the forum state in non-equity cases. That arguably affected the outcome of the case. See your statement second of judgment, section 87, comment A, page 315, 1980, hereinafter restatement. Since procedural... So that's the rule in the precedent case. I think it's a precedent case. Since procedural law largely determines matters that may be adjudicated in an action, state law had to be considered in ascertaining the effect of a federal judgment. The citation to Dupassier contains references with which you may be unfamiliar. The first citation refers to WAL. That is an abbreviation that refers to the reporter of decisions at the time, John William Wallace. The second citation includes L.ed. This is abbreviation for Lawyers Edition, which is an unofficial source for Supreme Court opinions. So, I also missed making a connection note. The court notes that removal to Maryland federal court on the basis of diversity jurisdiction was unavailable because the defendant was a Maryland citizen. Recall our study of removal jurisdiction in Chapter 3. Why was such removal not possible, but removal based on federal question jurisdiction was possible? The court then notes that the matter was remanded to Maryland State Court because the federal question arose only by way of defense. Why was that an issue that undermined the existence of federal question jurisdiction? Yeah. I don't have an answer for that. It's curious. So, respondent, for its part, now after the rule in the preceding case that is much dated, respondent, for its part, contends that the outcome of this case is controlled by Federal Rule of Civil Procedure 41B, which provides as follows: involuntary dismissal, effect thereof. For failure of the plaintiff to prosecute or to comply with these rules or any order of court, a defendant may move for dismissal of an action or of any claim against the defendant, unless the court in its order for dismissal otherwise specifies a dismissal under this subdivision, and any dismissal not provided for in this rule other than a dismissal for lack of jurisdiction, for improper venue, or for failure to join a party under Rule 19 operates as an adjudication upon its merits. Okay, so this is probably the operative rule, since we are studying civil procedure, and it comes from the Federal Rule of Civil Procedure 41B. Since a dismissal here did not otherwise specify in parentheses or in quotations, indeed, it specifically stated that it was, quote, on the merits, and did not pertain to the accepted subjects of jurisdiction, venue, or joinder, it follows, respondent contends, that the dismissal is entitled to claim preclusive effect. Implicit in this reasoning is the unstated minor premise that all judgments denominated on the merits are entitled to claim preclusive effect. That premise is not necessarily valid. The original connotation of an on the merits adjudication is one that actually passes directly on the substance of a particular claim before the court. Restatement, Section 19, Comment A at 161. That connotation remains common to every jurisdiction in which we are aware. See, I bid the prototypical judgment on the merits is one in which the merits of a party's claim are in fact adjudicated for or against the party after trial of the substantive issues. And it is, we think, the meaning intended in those many statements to the effect that a judgment on its merits triggers the doctrine of res judicata or claim preclusion. See Park Lane Hosiery Co. v. Shore of 1979. Under the doctrine of res judicata, a judgment on the merits of a prior suit bars a second suit involving the same parties or their privies based on the same cause of action. I like the way that's stated. And we will read that case later. But over the years, the meaning of the term judgment on the merits has gradually undergone change, and it has come to be applied to some judgments, such as the one involved here, that do not pass upon the substantive merits of a claim and hence do not in many jurisdictions entitle claim preclusive effect. This is why the restatement of judgments has abandoned the use of the term because of its possibly misleading connotations. Restatement 19, Comment A at 161. In short, it is no longer true that judgment on its merits is necessarily a judgment entitled to claim preclusive effect, and there are a number of reasons for believing that the phrase adjudication on the merits does not bear that meaning in Rule 41B. To begin with, 41B sets forth nothing more than a default rule for determining the import of a dismissal. A dismissal is upon the merits, with the three stated exceptions unless the court otherwise specifies. This would be a highly peculiar context in which to announce a federally prescribed rule on the complex question of claim preclusion, saying in effect all federal dismissals, with three specified exceptions, preclude suit elsewhere unless the court otherwise specifies. So I don't know if this is like a deconstruction of the rule or legislative intent, but it is a form of analysis. And even apart from the purely default character of Rule 41B, it would be peculiar to find a rule governing the effect that must be afforded federal judgments by other courts ensconced in rules governing the internal procedures of the rendering court itself. Indeed, such a rule would arguably violate the jurisdictional limitations of the Rules Enabling Act, that the rules shall not abridge, enlarge, or modify any substantive right, giving Section 2072B of the United States Code under Title 28, as cited in Ortiz v. Fiberboard Corp., 1999, adopting a limiting construction of Federal Rule of Civil Procedure 23B1B in order to minimize potential conflicts with the Rules Enabling Act and to avoid serious constitutional concerns. In the present case, for example, if California law left petitioner free to sue on this claim in Maryland even after the California statute of limitations had expired, the federal court's extinguishment of that right through Rule 41B's mandated claim preclusive effect of its judgment would seem to violate this limitation. Right. I just, in short, don't think that facts were heard if it was time barred. And if facts are not being heard, I don't think claims are being judged on the merits. Moreover, as so interpreted, the rule would, in many cases, violate the federalism principle of Erie Railroad Co. v. Tompkins, 1938, by engendering substantial variations in outcomes between state and federal litigation, which would likely influence the choice of a forum. Citing Hannah v. Plummer. See also Guarantee Trust Co. v. York, Walker v. Armco Steel Corp., which are all not in date sequential order. Hannah v. Plummer, 1965. Guarantee v. York, 1945. Walker, 1980. With regard to the claim preclusion issue involved in the present case, for example, the traditional rule is that expiration of the applicable statute of limitations merely bars the remedy and does not extinguish the substantive rights, so that dismissal on the grounds does not have claim preclusive effect in other jurisdictions with longer unexpired limitation periods. See Restatement Second of Conflict of Laws, Section 142 to 143 of 1969. Restatements of Judgments, Section 49, Comment A, 1942. Out-of-state defendants sue on the claims in California in other states adhering to this traditional rule would systemically remove state law suits brought against them to federal court, where, unless otherwise specified, a statute of limitations dismissal would bar suit everywhere. Finally, if 41B did mean what respondents suggest, we would surely have relied upon it in our cases, recognizing the claim preclusive effect of federal judgments in federal question cases. Yet, for half a century since the promulgation of Rule 41B, we have not done so. That's another form of analysis. We think the key, I think it's on legislative intent. We think the key to a more reasonable interpretation of the meaning of operates as an adjudication upon the merits in Rule 41B is to be found in 41A, which, in discussing the effects of voluntary dismissal by the plaintiff, makes clear that an adjudication upon the merits is the opposite of a dismissal without prejudice. Unless otherwise stated in the notice of dismissal or stipulation, the dismissal is without prejudice, except that a notice of dismissal operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in any court of the United States or of any state of action based on or including the same claim. See also Wright and Miller on Rule 41 use the phrase without prejudice as a contrast to adjudication on the merits. With prejudice is an acceptable form of shorthand for an adjudication upon the merits. And the primary meaning, which happens, it was actually a motion of summary judgment with prejudice, I think, by the DC of California. The primary meaning of dismissal without prejudice, we think, is dismissal without barring the plaintiff from returning later to the same court with the same underlying claim. That will also ordinarily, though not always, have the consequence of not barring the claim from other courts, but its primary meaning relates to the following court itself. Thus, Black's Law Dictionary defines dismissed without prejudice as removed from the court's docket in such a way that the plaintiff may refile the same suit on the same claim, and defines dismissal without prejudice as a dismissal that does not bar the plaintiff from refiling the lawsuit within the applicable limitations period. We think then the effect of the adjudication upon the merits default provision of Rule 41B and presumably of the explicit order in the present case that use the language of that default provision is unlike a dismissal without prejudice. The dismissal in the present case barred refiling of the same claim in the United States District Court for the Central District of California. That is undoubtedly a necessary condition, but it is not a sufficient one for claim preclusive effect in other courts. Part 3 of this court's majority opinion. Having concluded that the claim preclusive effect in Maryland of this California federal diversity judgment is dictated neither by Du Passeur versus Rochereau as petitioner contends, nor by Rule 41B as respondent contends, we turn to consideration of what determines the issue. Neither the full faith and credit clause of the United States Constitution, Article 7 and 1, nor the full faith and 4 and 1, nor the full faith and credit statute of Section 1738 of the United States Code under Title 28 addresses the question. By their terms, they govern the effects to be given only to state court judgments, and in the case of the statute, to judgments by courts of territories and possessions, and no other federal textual provision, neither by the Constitution nor of any statute, addresses the claim preclusive effect of a judgment in the federal diversity action. It is also true, however, that no federal textual provision addresses the claim preclusive effect of a federal court judgment in a federal question case, yet we have long held that states cannot give those judgments merely whatever effect they would give their own judgments. They must accord them the effect that this court prescribes. See Depositbank v. Frankfurt in 1903 and other cases. The reasoning of that line of case suggests, moreover, that even when states are allowed to give federal judgments, notably judgments in diversity, no more than the effect accorded to state judgments, that disposition is by direction of this court, which has the last word on the claim preclusive effect of all federal judgments. It is true that for some purposes and within certain limits, it is only required that the judgments of the courts of the United States shall be given the same force and effect as are given the judgments of the courts of the states wherein they are rendered. But it is equally true that whether a federal judgment that has been given due force and effect in the state court is a federal question reviewable by this court, which will determine for itself whether such judgment has been given due weight or otherwise. When is the state court obliged to give the federal judgments only the force and effect it gives to state court judgments within its own jurisdiction? Such cases are distinctly pointed out in the opinion of Justice Bradley in Du Pasteur sur vers Rochereau, which stated that the case was a diversity case applying state law under state procedure. In other words, in Du Pasteur, the state was allowed, indeed required, to give a federal diversity judgment no more effect than it would accord one of its own judgments, only because reference to state law was the federal rule that this court deemed appropriate. And short, federal common law governs the claim preclusive effect of a dismissal of a federal court sitting in diversity. See generally R. Fallon, D. Meltzer, and D. Shapiro. Hart and Wechsler's The Federal Courts in the Federal System, 1473. 4th edition, 1996. Deegan, Federalized Res Judicata, Yale, 1976. It is left to us then to determine the appropriate federal rule. And despite the sea of change that has occurred in the background, not only background law since De Pasteur was decided, not only repeal of the Conformity Act, but also the watershed decision of this court in Erie, we think the so this is an analysis of maybe historical context. So talking about the repeal of the Conformity Act, watershed decision of this court in Erie, we think the result decreed by Du Pasteur continues to be correct for diversity cases. Since state rather than federal substantive law is at issue, there is no need for a uniform federal rule. And indeed, nationwide uniformity in the substance of the matter is better by having the same claim preclusive rule. The state rule apply, whether the dismissal has been ordered by the state or a federal court. This is, it seems to us, a classic case for adopting as the federal prescribed rule of decision, the law that would be applied by state courts in the state in which the federal diversity court sits. And he's citing Gasparini v. Center for the Humanities. I think that's the holding of this case because that's really well put. In fact, I'll read it again. So this is, it seems to us, a classic case for adopting as the federally prescribed rule of decision the law that would be applied by state courts in the state in which the federal diversity court sits. As we have alluded to above, any other rule would produce the sort of forum shopping and inequitable administration of laws that Erie seeks to avoid. We didn't like federal common law after Erie. And that's a citation from Hanna. Since filing in or removing to federal court would be encouraged by the divergent effects that the litigants would anticipate from likely grounds of dismissal. See Guarantee Trust Co. v. York. This federal reference to state law will be obtained, of course, in situations in which the state law is incompatible with federal interests If, for example, state law does not accord claim preclusive effect to dismissals for willful violation of discovery orders, federal courts' interest in the integrity of their own processes might justify a contrary federal rule. No such conflict with potential federal interests exists in the present case. Dismissal of this case, state cause of action, was decreed by the California federal court only because California statute of limitations so required, and there is no conceivable federal interest in giving that time bar more effect in the courts than the California courts themselves would impose. Because the claim preclusive effect of the California federal court's dismissal upon the merits of petitioner's action on statute of limitation grounds is governed by the federal rule that in turn incorporates California's law of claim preclusion, the content of which we do not pass upon today. The Maryland Court of Special Appeals erred in holding that the dismissal necessarily precluded the bringing of this action in the Maryland courts. The judgment is reversed. The case is remanded for further proceedings, not inconsistent with this opinion. It is so ordered.